This show is exactly what what the theme of this show is all about, because we're trying to help you people who have too much debt, who've gotten caught in situations that you're not happy about, and you need a little bit of help, just a little bit of help to nudge you over the line. And that's why today we're talking about bankruptcy basics.
Welcome to Lewis on the Law.
Powerful beyond measure. Alyssa, that is the word of the day. That's the theme of this show. We're here to empower people. And on that note, I've got a great show full of empowerment details for you. It's on bankruptcy law. And I'd like to welcome back Alyssa Maloof Whatley from the law offices of Alyssa Maloof Whatley, if I can get that out. Yeah, that's right. Let's get a little round of applause. And she's here to talk to us about bankruptcy law. Is that correct?
Yeah, so we're just going to cover the basics of bankruptcy, maybe who's a good candidate, why you would file, and which chapters you would file. So we're just going to go all over the general basics.
And there you have it, straight from her herself. You're listening to Lewis on the Law. My name is James Lewis. Of course, I'm here with Alyssa Maloof Whatley. We're going to talk about bankruptcy basics today. So, Alyssa, who makes a good candidate?
So typically people that would make a good candidate for bankruptcy are people that are facing large amounts of debt, right? Not $2,000 or $3,000, not even sometimes not even $10,000, somewhere in a higher range that they really can't deal with, that are facing imminent collection action, right? So that would be a lawsuit, a garnishment, a foreclosure, a bank levy, a wage garnishment, something that's
so they don't drag people down and put them in the stockades anymore or anything like that?
No. There's no more debtors' prisons, right? We don't do that anymore to people. And, you know, I always joke with my clients, I wouldn't file bankruptcy until something forced me to file. So a lot of times people come in, they're like, I'm ready to file today. And you're like, but not yet. Pump the brakes. You're not even in danger yet. Nothing has happened to you. Maybe these creditors don't even come after you and you don't even have to file. Right. So a lot of times I have to slow people down and prevent them from.
Now does bankruptcy ruin your credit? Because that's the only holdback. I mean, I have a lot of debt myself. I mean, I hate to admit it, but I ran up my credit cards pretty heavily. And does it ruin your? But I've got a good solid credit score because I pay my bills on time. Does it ruin your credit?
So it can affect your credit. So normally what happens with people, and again, it depends, right? Like if you're already behind on your bills and maybe you have late notices, you're in collections and maybe you have some lawsuits and some liens out there, your credit score is probably not great anyways, right? So filing bankruptcy really wouldn't hurt you that much further. And a lot of times what happens is it might go down once they file bankruptcy, but once they get out, it starts to go back up.
Oh, okay. So that's another criteria, is be somewhere near the bottom of the line before you actually go there, right?
Well, yeah. I mean, I wouldn't base whether or not you should file on your credit score. I would just base it on, are you ever going to be able to pay off these debts? Do you have something imminent that you are facing? And another thing that I put in there is it's affordable, right? So a good example is like if I have someone that owes $5,000 of credit card debt, I don't know that makes sense for them to file bankruptcy because it's, $2,500. It can range like a $1,500, $2,500 for a Chapter 7. When somebody that has maybe $90,000 of credit card debt, we can't settle $90,000 because they don't have any money to settle with. So that person, right, they could pay $1,500 to $2,500 and be done with everything.
Okay, that makes complete sense. So what different types of bankruptcy actions are there? Because there's more than one, right?
Yeah, so there are actually a few different chapters, but the most common ones for consumers, and by consumers, I mean everyday people, not corporations or,
What, corporations aren't consumers? I thought they're everyday people. Wasn't there some big case where now a corporation is a person?
Yeah, well, not in the bankruptcy sense. So we're going to focus on a Chapter 7, which is a liquidation bankruptcy, a Chapter 13, which is a reorganization. Briefly talk about 11s, which are more based towards companies and restructuring, but not for the everyday person.
Okay, so what kind of stuff can happen that you really want to stop bankruptcies from getting into? Like your wages being garnished? Can a bankruptcy stop that?
Right. So the cool thing about bankruptcy is there's this thing called the automatic stay, and I call it like a bankruptcy bubble. I know no one can see me doing a bubble over my head because it's the radio.
People, because we are live, we go out on all kinds of mediums here.
All right, so bankruptcy bubble. The
That's
automatic.
right. Look at the cameras nicely and say bankruptcy bubble.
Bankruptcy bubble. And the bankruptcy bubble is the automatic stay. And what that does is it immediately stops all types of collection actions and protects the debtor. So whether that's a repossession, right, that it hasn't happened yet, and even sometimes, even after the car has been repossessed, if you file bankruptcy within a few days, you can get your car back. A bank levy, right? So a bank levy is a one-time hit on your bank account. It's not a continuing thing, but a lot of times if you file bankruptcy, that will immediately release that. A wage garnishment, like you said, somebody automatically taking payments out of your paycheck. For example, I had a client that had the Colorado Department of Revenue was levying her paycheck 50%. So if she would have filed bankruptcy right away, that would have immediately stopped that action. Seizures, foreclosures, it will stop a foreclosure.
It'll stop a foreclosure?
Wait
a minute, bankruptcy will
foreclosure.
That is a really good thing to know.
Yes. So
I do some foreclosure defense, and I didn't actually know that.
Yep. So bankruptcy will protect them right away. So, what's kind of crazy is the Tuesday, foreclosures happen on the first Tuesday of every month. Bankruptcy filings go way up. Like right that Monday at like 5 p.m., people are like, can you file bankruptcy? My advice is someone, if you're facing foreclosure, you have notice in advance, right? Because they have to go through a process where they notify you that your property will be up for sale. Don't wait until like the Monday before foreclosure day. Go see a bankruptcy attorney before. Most of the time they do free consultations. They let people file with little to no money down. So, if you wait to file, a lot of people are going to charge you more because you made it into an emergency situation when you could have seen them sooner.
Okay, that is really good to know. So it'll stop a foreclosure and the repossession?
Yep.
Wow, that's incredible. How about student loan debt?
So it doesn't discharge student loan debt, and actually that's kind of been a big contention, I think, for bankruptcy practitioners and people involved in bankruptcy, because the goal of bankruptcy is to provide the honest but unfortunate debtor a fresh start. And so when you're able to file bankruptcy and get rid of credit card debt and medical bills, but then you still walk out and you owe $250 on a student loan, that doesn't really embody the principles of a fresh start to me. And I think it's going to be something that our society has to deal with in the future. You are able to discharge some student loans under like a hardship discharge. It's very difficult. The rules are not very clear. And most people don't qualify for that. So, people should write their congressman to change the federal bankruptcy laws to get student loan debt included in certain situations, because, like I said, it doesn't really embody the fresh start if you get out of bankruptcy and then you still owe a bunch of student loans.
Yeah, you got student loans. And how about IRS debt?
So, I am a tax attorney, and my favorite thing to do is actually teach bankruptcy lawyers tax law and how bankruptcy and tax law intersect. So bankruptcy can actually discharge some types of taxes. There's just 5 general requirements that have to be met. It has to be for income taxes. There are certain types of taxes like trust fund taxes, like employment tax, sales tax, those kind of things where if you're personally liable and you were holding that money in trust and you didn't turn it over, that's not dischargeable, right? Because that was something that was held in trust and you violated that trust. Income tax, it has to be assessed at least 240 days before filing bankruptcy, has to be at least 3 years old, has to be a tax return filed 2 years before filing bankruptcy, and you can't commit fraud or willful evasion. So if you meet all those rules, then you can get a bankruptcy discharge for taxes.
Wow. Okay, so you can't commit fraud or willful evasion. So that goes out with me running up a big IRS tax debt because I'm a private person now. I'm no longer an employee. So I can't just go ahead and discharge my huge IRS tax debt just to get out of it.
Well, a lot of people can. It's not necessarily the amount. What the IRS looks for in willful evasion, which is one of my favorite things, is they look to see how you spent your money and if you always continue to owe. So maybe you owe for 10 years in a row, and then you bought a Porsche and a mansion and you sent your kids to private school. That would constitute maybe willful evasion, where you consistently, it's called pyramiding, kept adding tax, and then maybe spent your money and when you could have been paying your taxes.
Well, that's good to know. And that was just a joke. I do not avoid my taxes. I pay quarterly self-employment taxes to keep myself straight. I already know the game. I've spent some time in the tax clinic myself. Alyssa, why don't you give them some contact information while you're here?
Yeah, people can reach out to me via my website at www.atltaxlawyers.com. Shoot me an email at alyssa@whatleytaxlaw.com or call me directly at 404-551-5838.
You're listening to Lewis on the Law. We have an awesome show for you today, a show that's all about empowerment. We're going to be talking about bankruptcy law and bankruptcy basics. This show comes to you each and every single week, and what we do is we give you legal information. This is not to replace the advice of an attorney. If you have a serious legal issue, you need to go ahead and contract with an attorney. You can contact me at jameslewislegal.com, and if I can help you with your issue, I will. If I can't, I'll point you in the direction of an attorney who can help you with your issue. If you have a topic that you'd like to hear on this show, go ahead and drop me a line on my webpage, and if I like your topic and I think it's good enough, I'll get an attorney who actually knows something about your topic, bring them on air, and we will talk about it. We've got a lot of stuff coming up for you. We're going to get into the different types of bankruptcy available, basically. So we got more when we're back in just a moment, okay? You are listening to Lewis on the Law. My name is James Lewis, and I'll be your host for the next 48 minutes or whatever. I don't know. We've used up like 10 or 12 minutes. I was never good at math, Alyssa. That's why I did not go into anything that required math. I was like, you know what? I can read and write real good, so I'll go into something that I could just read and write my way through. I'm here on the show right now, live with Alyssa Maloof Whatley. Alyssa, give them some contact information for you.
Yes, I can be reached at my website at www.atltaxlawyers.com. You can reach me via email at alyssa@whatleytaxlaw.com or reach out to me via phone 404-551-5838.
Awesome. And this show is exactly what the theme of this show is all about, because we're trying to help you people who have too much debt, who've gotten caught in situations that you're not happy about, and you need a little bit of help, just a little bit of help to nudge you over the line. And that's why today we're talking about bankruptcy basics. Alyssa, let's talk about the different types of bankruptcy right now. So I know Chapter 7 is one. What does that mean?
So a Chapter 7 is what's called a liquidation bankruptcy. And that sounds very scary, right? Like, what are they going to liquidate? But most everything, right? But most debtors don't know is that they don't really have any unexempt assets that can be liquidated. So although you may have things of value, like a home or a car or jewelry or money in a bank account, maybe a legal claim, the IRS, well, they don't have any exemptions. The Federal Bankruptcy Code allows for exemptions, and actually states can choose to opt into federal exemptions or pick their own state exemptions. So Georgia has our own exemptions. For example, for a home, the exemption is $21,500. So how a liquidation bankruptcy works is, let's say you had a house that was worth $150,000 and you owed $140,000. You have $10,000 technically of equity. I mean, not counting the sale cost. Right. But that $21,500 homestead exemption would protect that equity. So they wouldn't be able to liquidate it because you're protected. So they have exemptions for cars, bank accounts, all of those things. So if everything that you have is either encumbered by a loan or exempt, then there's nothing to be liquidated. And what ends up happening is you get a discharge of all of your unsecured debts, which could be credit cards, medical bills. You end up paying nothing back. And then there's nothing liquidated. So in the short of it, even though this type of bankruptcy sounds scary, you may still be able to keep your home, your car, and your bank account. Right. So it's actually really great. Oh, and retirement accounts, there's exemptions for those as well. So it's actually a really great program. Like we said, the goal of bankruptcy is to provide the honest but unfortunate debtor a fresh start. And so by allowing them to exempt some of their equity and assets, that creates that foundation that allows them to have a fresh start and have something to start with. Okay, so what is the time frame on this type of bankruptcy? I mean, how long does all this take to happen? I mean, when should a person take this action? Yeah, so a Chapter 7 typically lasts 3 to 6 months, and how it starts was with the filing of a petition. Once you file a petition, you normally get a court date about 30 days after, and so you do have to go to court. You have a short little hearing. You're most of the time there with your attorney and the trustee that's been assigned. They ask you a few questions under oath that are based on the petition that you filed. And then you do have to complete a credit counseling course, which I think is a great thing. it's required by federal law that you take credit counseling so that you don't get in that position again. And a lot of reasons why people are in bankruptcy is because they didn't have that financial education. They don't know how interest rates work. They don't know how loans work. And so by requiring them to take that course, the hope is that they won't ever have to come back to bankruptcy. But so they take that course, and about 2 months after that, you get a discharge and you're on your way.
That almost sounds too good to be true. Now, who is a good candidate for this? I guess just not everybody is a good candidate for Chapter 7. I mean, what makes an ideal candidate for this type of bankruptcy?
Right. So a Chapter 7, I like to call it like the golden ticket. So what everybody wants. You know, they listen to these things on the radio.
You keep your house, you keep your car, you keep your bank account, your retirement fund, and all you do is get rid of your credit cards. It sounds golden to me.
It sounds awesome, and it's what everybody wants. But what people don't realize is you have to actually qualify for a Chapter 7. And you have to meet the means test. And the means test is based on the median IRS standards of living for the number of people in your household size. So, for example, if you're a household of one, that's typically somewhere around $46,000. It changes every year based on inflation. Like they have a certain dollar amount. And a lot of times we're able to, if they're slightly over that amount, we're able to pull them down when they pay their taxes or secured debts to get them under the means test so that they qualify. But it's based on household size. So that would be, what the trustee always says, heads on beds, right? So household of 2, household of 3, and whatever that number is. So if, for example, you're somebody that makes $100,000 a year and you're a household of 1, you're not going to qualify for a Chapter 7 because you make too much money. And you might have to file a Chapter 13. So one of those requirements is income. Okay. You have to meet the means test. The second thing is, if you want to keep your property, you have to be current on it. So, for example, we're talking about keeping your house or keeping your car. If you're facing a repossession or a foreclosure, filing Chapter 7 is not going to save them. It will buy you time, right, because it will stop that action. But you're not going to be able to keep it because 3 to 6 months a lot of times isn't enough time to catch up on those payments, right? So if you're like $15,000 behind on your mortgage, 3 to 6 months isn't going to do much for you. It's just going to buy time. So if you want to keep your property and you're behind on it, again, we might have to look at a 13. And then another issue or that I was going to put is if you have equity in assets, right? So let's say you do have a home and you don't have enough exemptions. You have $50,000 of equity and the exemption is only $21,500 for one person. Then you might want to deal with your debt, but you're like, I don't want to give up my house, right? And so in that case, that person might want to file a Chapter 13 because they can still reorganize and get rid of their debts and pay less back, but they don't have to give up their home. One way around the means test that I always like to bring to people's attention that they don't know is if more than 50% of your debt is non-consumer debt. And what is consumer debt? Consumer debt's credit cards, cars, houses, things that you're consuming, right, that you're buying. If it's business debt, like you took out a loan to start a new business or you are co-signed on a business debt, or taxes are a business debt. If more than 50% of your total debt is business debt and non-consumer debt, you don't have to take the means test.
Oh, that is really interesting. So I should take out a small business loan, is what you said. My banker actually offered me when I'm like, there's no way I can handle any more debt right now. Sounds really good, but I'm afraid.
So a lot of times I'm able to, maybe they have more taxes than they do anything else. Well, now that person doesn't have to meet the means test because more of their debt is business debt and they can file a business Chapter 7. And that gets around. That's why you hear of all these rich people filing a Chapter 7 and getting like, well, wait, they didn't meet the means test. They don't have to because their debt is not consumer debt. It's business debt, non-consumer debt.
Wow. Okay, there you have it. That is something that is great information out there. All of you guys who want to actually get rid of your debt, just pack up a lot of business debt. No, that's not good advice. Never mind. I just said what I was afraid to do. Okay, so are there any exceptions? Oh, I guess we've already talked about the exception about that. Is there anything else we need to know about Chapter 7 here?
Well, yeah, like we talked about, you got to be current on your payments, and a lot of people are scared that. So let's say you are current, right? You're current on your home, you're current on your car. Really, you're just dealing with credit card debt. Chapter 7 is great, right? Cheap, fast, qualify. But you can still keep your house and your car. And how you would do that is what's called a reaffirmation agreement. So basically, what a Chapter 7 does is there's a security interest and a promissory note. And the bankruptcy extinguishes the promissory note, which is the I promise to pay you X amount of dollars, right? But the security interest remains, like the security deed on the home or the title on your car. Those things would not be extinguished with the bankruptcy. So what you can do if you really want to keep those things and you want to re-obligate yourself on a promissory note, that creditor, if you're current, will allow you to re-sign that promissory note, and you'll be able to keep it like nothing had changed.
Okay, that is good to know. So are you ready to move on to Chapter 13?
Well, already? Yeah, we can do that if you want.
Is there more? Is there anything more you want to say about Chapter 7? Because it seems like there's a lot that you just went over.
Yeah, I mean, I think that's pretty much the basics of a Chapter 7 is just knowing that, making sure that you know that you qualify, that you understand that if you're not current on things, you can't keep them, and, not forcing yourself into bankruptcy. So I don't know that I would file a Chapter 7. Like if someone was suing me and my bank account hasn't been garnished yet, I would maybe wait. Right? I would wait until something happened that was imminent, that was going to force me to file bankruptcy. I wouldn't just file it just because I was worried or concerned that something in the future might happen.
Okay, so that is really good information to know. Now, I think we're going to hold off on Chapter 13 until the next segment. Alyssa, one more time, I want you to give them some contact information for you.
Yes. You can reach out to me via my website at www.atltaxlawyers.com. Email me at alyssa@whatleytaxlaw.com or give me a call at 404-551-5838.
You're listening to Lewis on the Law, and we are all about empowerment. There's nothing that embodies that than empowering people to get themselves out of debt. And that's why this show is awesome. It's a godsend, Bankruptcy Basics. You're listening to Lewis on the Law. I am here every week. My name is James Lewis. I am your host, and I bring you legal information, not legal advice. This is not to replace the advice of your attorney. If you have a serious legal problem, go ahead and contract with an attorney. You can always contact me. I might be able to help you with your legal issue. If not, I can direct you to an attorney that can. Just contact me at jameslewislegal.com. You can email me at james@jameslewislegal.com or give me a call at 404-610-0075. We'll be right back with Chapter 13. You are listening to Lewis on the Law. My name is James Lewis, and Joey, my producer here, is making fun of me, but I love that band. I love that kind of crazy, instrumental stuff. When I was in law school, I used to listen to stuff like that on headphones all day long because it would block absolutely everybody out, and I could just get absorbed into stuff. We have an awesome show for you guys today. We are talking bankruptcy basics, the true meaning of empowering you, the listener. I have Alyssa Maloof Whatley here on the show with me, and she is an expert in this area. Alyssa, give them some contact information just in case you have a bankruptcy problem. You might want to contact her before you actually take any action for debt relief.
Yes, so feel free to reach out to me anytime. I offer free consultations. My website is www.atltaxlawyers.com. via email at alyssa@whatleytaxlaw.com or call 404-551-5838.
Awesome. Alyssa is a great bankruptcy attorney, and we're going to get into Chapter 13. We just went through Chapter 7, and it's a liquidation bankruptcy, and she basically went through the ways in which you can save your house, your car, or you may have the option to save your house, your car, your bank account, your retirement fund. Now, Chapter 13, how does Chapter 13 differ from Chapter 7?
So Chapter 13 is a lot more complicated and complex than a Chapter 7. So whereas a Chapter 7 is very short, it's 3 to 6 months, a Chapter 13 actually lasts 3 to 5 years. So it's something that people should really think about and make a commitment to, because unfortunately what happens is they think that they need to file a Chapter 13 and they get into it and then they have a hard time staying in the Chapter 13 because it's such a long commitment. And basically, a Chapter 13 is more of a debt reorganization. So what they do is they kind of consolidate all of your debts into one monthly payment. You make that payment to the trustee. The trustee distributes the money to your creditors based on the plan created by your attorney.
Okay, so this last 3 to 5 months, you basically now how do they consolidate this? What do they do? I mean, how do they figure out the number that you have to pay each month?
Right. So 3 to 5 years.
Okay,
long time.
Okay, it's 3 to 6 months for the other one, 3 to 5 years here.
Right.
Okay, so it seems like it's still a big deal here. I mean, you've got 5 years commitment, 3 to 5 years,
right?
And there's an amount you have to pay. How do they figure that out?
So that amount is based on a few things. The first thing that they do is, remember that test I was talking about, the means test. We don't completely avoid it in a Chapter 13. Basically, what they do is they use the means test to determine how long you're going to be in bankruptcy, right? So if you're over the means test, which is the median household standards for IRS standards of living for the amount of people in your household and the county in which you live, if you're over that, then you have to be in bankruptcy for 5 years. If you're under that, you have the option, you can do a minimal applicable commitment period of 36 months or 3 years. So basically, how much you earn determines on how long you're going to be in bankruptcy, right? So that's the first issue. Then what they do is it's based on everything that you need to pay, right? So, for example, if you have secured debts, like mortgage, right? You wouldn't pay your whole mortgage through Chapter 13 because you wouldn't be able to pay it off in 3 to 5 years. But what you would be able to pay off in 3 to 5 years is a car payment. So we normally put the whole car into the Chapter 13, whatever that balance is, right? Then we would put your mortgage arrears. And arrears are how far you are behind, right? So let's say you're 2 or 3 months behind on mortgage payments, and maybe that's $5,000. Then you would pay $5,000, right? Mortgage arrears would go in there.
Wait a minute. Let me ask you a question about that, because that's something that might really be applicable to a lot of people. So if your mortgage is in arrears, you can put the amount that's in arrears into Chapter 13 and then stay current with your payments. Is that correct?
Right. So basically how it works in a Chapter 13 is we're reorganizing everything. So we're taking secured debts. The cars we mainly put in, and we can adjust your interest rate, which is good. So we can negotiate that. So a lot of times people have terrible credit and they're in a terrible deal. Like I've seen car loans that are like 19.999% interest rate.
Wow.
And so in a Chapter 13, we're actually able to maybe change that to something more reasonable, like 4 or 5%. And then with the mortgage arrears, yes, we would put the amount you are behind into your plan that would be paid back over 3 to 5 years. And then once you're in bankruptcy, you have to stay current on your monthly. So it's like you get like a start over, because the old debt is going into the plan, and then once your bankruptcy starts, you keep paying your monthly mortgage payment as normal. So that's a great thing. But the caveat with the 13 is you don't just get to pay for things that you want to keep. And that's always what's really upsetting to debtors. It's like, okay, well, I want to keep my house, so I'm going to pay for that. And I want to keep my car, so I'm going to pay for that. But I don't want to pay anything. I don't want to pay anything else. I don't want to pay the taxes. I don't want to pay these other debts. Definitely don't want to pay credit cards. And so Chapter 13 really doesn't work like that. In order to keep the things that you want to keep, like a house or a car, you also have to pay 100% back priority debts. And so what are priority debts?
That was exactly my question. Well, what's a priority debt?
So priority debts are things like child support, alimony, taxes due within the past 3 years. Those types of items are not dischargeable because they have to be paid in full in order for you to keep the things that you want to keep. So a lot of times what happens is maybe they owe $100,000 in taxes for the past 3 years, and they want to keep their house and a car. Well, that payment plan is going to be very high because we have to pay those taxes back in order for them to keep their stuff. So that can be a problem with the Chapter 13, depending on how much priority debt you have. And then the other consideration is disposable income. So remember, we're talking about the means test. It's very complicated, guys. We deduct everything that you have to pay, right? Your mortgage, your necessary living expenses. And whatever you have left, they multiply that number by your applicable commitment period, right? So it could be 36 months or 60 months. And that is what we call the pool to unsecured creditors. So, that could add, let's say if you have $600 left over, disposable monthly income, and you're way over the median, we multiply that amount by 60, and that's what becomes the unsecured pool to creditors, right? So that would go to pay medical bills or credit card debt. So oftentimes, most people don't have any disposable income once we do the means test, and maybe they're under, so they don't have to pay anything back, and their pool to unsecured creditors could be nothing, right? It could be zero. But at the same time, it's really based on the ability to pay, what the means test is, and how much disposable income you have. The other reason you could have a pool sounds like it's a fun thing, but it's not.
Woohoo! Pool party.
Pool party. You're paying back a lot of your debts. The other reason you could have a pool is because you have unexempt equity and assets, right? So remember we were talking about in Chapter 7, if you didn't want that to be liquidated, you could file a Chapter 13. The only way the 13 works is if you pay back what the creditors would have gotten in a 7, right? So that kind of stinks because whatever that unexempt equity is, that dollar amount has to be paid in the Chapter 13, and that could cause your plan payment to be higher. So what they do is they take all those things that we're going to pay back, and we divide it by, if you have to, 60 months. But a lot of times, if you only are required to stay in for 36 months, what we do is we still divide it by 60 months because that's the maximum term that you can be in bankruptcy, because what it does is it lowers their payment, right? So they don't have to pay anymore because they're doing 60. We're just making their payments smaller because they have a lot more time to pay it back.
So the best type of candidate for this is a guy who has, or a family who has very little disposable income, no priority debts.
Well, I mean, everybody's most of the time has priority debts. It's helpful if you don't have priority debts. And the main reason people file a 13 is because they make too much money for a 7. They have equity and assets that they want to keep, or maybe they're not current on them and they want to keep them. They want to keep a house or a car. And a lot of times it's really upsetting because I have to tell people maybe it's not worth keeping.
That's a hard one, especially if it's a home. I mean, that's where a person's living.
Right. So if they're underwater on a home, and we saw that a lot in 2008, and I worked in the bankruptcy as a paralegal before I went to law school. I worked for a bankruptcy firm, I guess it was from 2010 all the way to 2015 when people were still recovering. And a lot of times we had to have those hard conversations with people. Why would you want to go into a 3 to 5 year payment plan to keep something that has no value?
That is a really, really hard sell. So then what is, in your words, is a really good candidate for this type of bankruptcy?
Somebody that has a steady source of income. You have to be able to pay for the plan, that has property that they want to keep, that they're behind on, or someone that doesn't qualify for a 7 and needs relief from credit card debt and maybe has a large amount of bills. That would be someone who would be a good candidate. And obviously they have to fit within the debt limit. So unsecured debt limit is $394,725,000, and the secured debt limit is $1,184,000. So if your debts don't fit within those limits and you don't qualify for a 7, that's where you fall into that Chapter 11 category.
Oh,
sometimes.
Scary stuff. Okay, Alyssa, we're approaching the end of this segment. Why don't you give them some contact information for you real quickly?
Yep. I can be reached at my website, www.atltaxlawyers.com, via email at alyssa@whatleytaxlaw.com, or give me a call at 404-551-5838.
You're listening to Lewis on the Law. My name is James Lewis. I will be your host for the next 12 or 15 minutes, however long we have. We have a lot more stuff coming back. We're going to talk about alternatives to debt relief when we get back. We'll also go to some additional items to consider on Chapter 13. If you have an idea for a show, you can contact me at jameslewislegal.com. Drop me a line, hit me a message, and if I like your topic, I'll bring an attorney on who actually knows something about your topic, and we'll get into the discussion right here. And when we come back, we'll be talking about more bankruptcy basics, alternatives to bankruptcy, and debt settlement issues. You are listening to Lewis on the Law. My name is James Lewis, and I am your host for the next 10 minutes. But I'll be back next week. It's not a threat. It's a promise, because I am here to empower you, the individual, with legal information, not legal advice. Definitely keep them separate. If you're in serious trouble, go ahead and contact an attorney. Don't rely on this show for your legal advice, but it is a first step process. If you need help, if you need to find your way through any legal matter and you have nowhere to turn to, you have no idea what to do, I have a whole bunch of these shows cataloged on my website. I'll have a whole bunch, even more topics cataloged on my website, eventually be a large catalog of legal information so you can find your first step in the process. You can find your way on how you might address a legal issue, what you're going to look for, what type of attorney you're going to look for, what are the things for you to consider. And today we're talking about bankruptcy basics. I have attorney Alyssa Maloof Whatley on the show with me. Alyssa, why don't you give them some contact information for you?
Yeah, people can reach out to me via my website at www.atltaxlawyers.com. Email me at alyssa@whatleytaxlaw.com or reach me via phone at 404-551-5838.
And you can always contact me, James Lewis, at my website, jameslewislegal.com. You can give me a call at 404-610-0075. Alyssa, are there additional items to consider on Chapter 13?
Yes, so there are quite a few things to consider. So not only that time frame we were talking about, it's a long time.
That's that's a commitment, 5 years?
3 to 5 years. In that time frame, the trustee is also monitoring your income. So if your income goes up, that's something that they could ask that you end up paying more money into your plan. If you come into some money, for example.
So you have to keep working at Burger King for those 5 years? I'm sorry, I should have said that for all you Burger King guys. I used to work at Wendy's. It was my very first job ever. Very respectable job. I flipped burgers.
Yeah. So, a good example is maybe you're working at Burger King, you got promoted to manager. Now you're making more money. That might be something the trustee is interested in because maybe now you could pay back more. They also will take your tax refunds. So if you're in 100,
ouch,
right? So that's money that's coming in that they want to go to creditors. So it depends. If you're in a full pay plan, like you're going to pay all of your creditors back in full, they will not take your tax refund. If you're paying a part of it back, they have a right to take your tax refund. But your bankruptcy attorney can actually file a motion to ask to keep the tax refund up to a certain dollar amount if you need it to pay for necessary living expenses. So when I was filing a lot of Chapter 13s and representing debtors, oftentimes I would file motions to keep the refund because obviously if we're taking all their disposable income, they don't have any money left over for emergency.
Wait a minute, does that work? Can you file a motion to keep the refund?
Yeah. So it really does help people. Like a lot of times their refrigerators went out or maybe their washer dryer or maybe they had a car repair. And obviously,
wait a minute, do you know something about refrigerator repairs and car repairs? Because I've got this little noise in my refrigerator that goes whoop, 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 like every 40. Never mind. Go ahead. Sorry about that.
I mean, they can't afford those things. Like most people have most Americans don't have any savings. But in bankruptcy, right, we're not allowing this debtor to accumulate any savings for emergencies. So a lot of times people are using their refunds for that purpose. And so it's important, to know that they could take a portion of that. But if you have a great attorney, which there's so many great ones in Atlanta, I'd be happy to refer people to because I'm no longer doing Chapter 13s. They can make sure that you get to keep that money. And then the other thing to think about, and you also have to pay trustee fees. So the trustee takes a percentage depending on which trustee it is, how much
they have to get paid too.
They have to get paid for administering the case. So a lot of times when I'm thinking about, well, should you file a Chapter 13? If you're not facing immediate collection action, if you're current on your obligations, I don't know that Chapter 13 is the best way to deal with certain things. Like for me, most of my clients have tax debt. Chapter 13 is not a good way to deal with tax debt. The IRS offers so many other great programs that I don't think it's a great way to deal with it. But for some people, depending on what their situation is, it can be a great a great resolution. The other thing to think about is you get a discharge. So for a Chapter 7, you get a discharge once every 8 years. So once you file Chapter 7, you can't turn around and file another 7, at least for 8 years. So a lot of times.
But you can every single 8 years, huh?
Yeah, and we have some serial filers, people that will do that. So sometimes people have to file a Chapter 13 because maybe they got their discharge in a Chapter 7, and so now they're going to file a 13 because it's not long enough in between, and so they're kind of forced into it. You can get a discharge in a Chapter 13 4 years after.
So you can get a Chapter 7 and then do a Chapter 13 a couple of years, 4 years later. Okay.
Right. So it goes filing date to filing date. So, that's the basics of bankruptcy. I think we should talk about some of the alternatives for the people that maybe heard all of this and now they're like, well, I don't know if I want to do that anymore.
Bankruptcy sounds like it's a dicey business, especially the whole 5-year plan. I mean, making that payment for 5 years, making sure your income doesn't go up during that 5 years, because who knows, you might get that promotion that you've always been dreaming of.
Right. So, yeah, I came from a bankruptcy background, and I'm no longer actually filed bankruptcy cases. I do consult. I do free consultations. I'm happy to refer people out to bankruptcy attorneys since I mainly specialize in tax and alternatives to bankruptcy. I think it's hard when you go to a bankruptcy attorney because that's all they do. So they might be like, well, this is the best option for you. But maybe it's not because that's all that they do there. And so maybe they're not aware of all the alternatives. So I'm more than happy. Like I said, I meet with people. Like today I met with a guy and he had a tax issue. And I was like, oh, man, you sound like a great Chapter 7 candidate. You should do that. Here's someone's number, and it for me, I'm happy to get them to the right place. When in another instance, maybe they went to a bankruptcy attorney first and they're like, oh, all you can do is file bankruptcy. And they don't know that there's so many other options, right? So I'm happy to talk to people about that. So a great alternative to bankruptcy, let's talk about debt settlement. So how does debt settlement work? Let's start with why you would even want to settle a debt. Let's say you owe Amex. I like to use Amex because they're aggressive. If you owe Amex and you don't pay them, right, they're going to say, oh, you have to pay us, you have to pay us, you have to pay us. And you're like, okay, cool. I don't have the money to pay you. And your interest is crazy. What happens eventually, right, is they file a lawsuit against you. And if you don't file an answer, right, they get what's called a default judgment, right? Basically, they win. If you file an answer, even if it's the stupidest answer, I don't owe it, even though you do owe it, or, I owe it, but I can't pay it, and you file it with the court, that buys you time. It gets you a hearing. They're still going to win, if they owe the debt. But that first step, that could be a year from when you stop paying them. That could be 2 years from when you stop paying them. And eventually when they get that judgment, what can they do with the judgment? Nothing. You owe it, but, they have to take other actions to actually collect that debt. Right now they have a piece of paper saying that you owe them. So if they wanted to do something to you, like file a bank garnishment or levy your bank account or do a wage garnishment, they have to actually file a separate lawsuit for that, right?
Now, wouldn't they do that, though? Isn't that their next step, is to begin to garnish your wages and levy your bank account and the whole nightmare? Right.
So, but they have to know where you bank or where you work. So if they don't know that information, it might take them a while to figure it out. And so that's why I'm always hesitant when people are like, I'm going to file bankruptcy because I owe Amex money. I'm like, have they sued you yet? And they're like, no. Have they garnished you yet? No. I'm like, well, they got like 4 steps. Really 2 steps. So, if it was me personally, I'm not running to file bankruptcy unless my bank account is on the verge of being levied. So if you have a small amount of debt, right, and you know all this information, if you have a small amount, a lot of times we can settle with these companies for 20 to 30% of what you owe.
Wait a minute, they'll actually do that? They'll settle their debt?
Right. And so the argument that we make here...
Well, why would anybody pay them the full amount then?
Right. It makes, like I said, it makes you want to go out and run up a bunch of credit cards.
It kind of makes it. I just got a couple of really good offers. Interest rates are respectable. I'm just like, what? That's money I could use right now.
Don't do it with Amex, though, because they are aggressive and a lot of times they won't settle. But a good example is, I had a guy, and the other thing I was going to tell you is to watch out for if something sounds too good to be true. It's like a nationwide debt settlement or debt resolution firm, and you can't go meet with them, touch them, talk to them. Don't give them your money. I had a client that paid a firm $10,000 to represent him to settle his debts with Amex, right? And 3 other creditors. They charged him $10,000 in legal fees to put him in a payment plan that was going to full pay Amex. Not only that, they signed a default judgment without his consent. And then what happened is they didn't send the money for his payment plan, and Amex ended up garnishing his bank account for $14,000, right?
Oh, my God.
Right. And that's just terrible. And so a good example is I think I charged him like $1,000. I called Amex. Well, that one was already done because he'd been garnished. But I called, his other card, Citi card, MasterCard, and I offered them 30%. I said, check will be in the mail in a week. They settled it, and it was done. And so you just
wait a minute. Does this do they still negatively impact your credit when you do this?
Yes. So it will say like full paid or like satisfied for less than the full amount owed, but they're not going to collect from you, and you didn't have to pay the full balance, and it's better than having like a negative collection action on there. The only caveat to debt settlement is you have to have the funds, right? You have to have money set aside, and you could get a 1099-C for cancellation of indebtedness, which would technically be income to you on your
pay
tax
taxes
return.
on that.
But there is an exception to that rule, and that would be bankruptcy or insolvency. So there's a way around that as well.
Wow. That was a lot of great information. Our show is almost over. Alyssa, one last time, real quickly, how to get in contact with you.
Yep. www.atltaxlawyers.com, Alyssa@WhatleyTaxLaw.com, or give me a call, 404-551-5838.
You're listening to Lewis on the Law. I'll be back next week with a great show on educational law with attorney Rainer Bettendorf. That's a mouthful. Love you guys. We'll see you next week.